Good afternoon, everyone. Hold on, I'm not. There we go. Okay, let's get started. We have 3 bill hearings today. Our first one is Senate Bill 4. Natalie, could you give us an overview, please?
Thank you, Mr. Chairman. Senate Bill 4 changes the criminal penalty for unlawfully tampering with electronic monitoring equipment. Current law in sorry, can you still hear me? Okay. Current law in KSA 216322 sets the penalty for that crime at a severity level 6 non-person felony. This bill would change that crime in the case of electronic monitoring equipment used for supervision of a felony offense to a severity level 8 non-person felony, and unlawful tampering in the case of equipment used for supervision of a misdemeanor or a civil case would be a Class A non-person misdemeanor. I would note that this bill is identical to House Bill 2027 as that bill was introduced. That bill was heard and passed out of committee with some committee amendments by House Corrections and Juvenile Justice. And I can take any questions.
Thank you. Do we have any questions for Natalie? We do not see any. Let's start with proponents, and Scott Schultz is joining us today on WebEx.
Mr. Chair, good afternoon, members of the committee. Can you hear me okay?
Yes. Yeah. Yes.
Great. Well, thank you on behalf of the Sentencing Commission. I am here to support this particular bill. The overarching theme here would be the word unanimous. It has received unanimous support from the Sentencing Commission to pass this particular bill. It has received 2 years in a row unanimous support from the Kansas Criminal Justice Reform Commission. And as I've indicated in my testimony, the Senate placed this on consent calendar and passed it out 39-0. So this is a proportionality bill. The current offense or severity level for this offense is a severity level 6. The bill asks to basically make a 2-tiered approach to this and reduce the penalty to a severity level 8 if an individual's been charged with a felony. Most of the time, this is doing essentially is the electronic monitoring device is a ankle monitor. And so if I cut off this $28 ankle bracelet, then I'm in violation and can be charged. Some of the, again, from a proportionality standpoint, not only the Reform Commission, but also the Sentencing Commission, you can easily look at this in terms of what does aggravated escape from custody look like. Most of those provisions or subsections are level 8s instead of level 6s. And so, for example, if I break out of jail, that's a level 8. But if I cut off my ankle monitor, it's a level 6. If I'm a sex predator and I'm getting ready to be committed, and I run away, that's a level 8 versus cutting off my ankle monitor. Currently, unfortunately, if I get tagged with stealing a pack of gum at the grocery store, and for whatever reason I'm placed on electronic monitoring, if I cut that bracelet off, it's now a severity level 6 felony. So obviously, there's some disproportionate situations that actually occur to this, and in a disproportionate sense as well. What you currently have as far as the current crime is concerned at a level 6, that arises to the same level as some levels of aggravated battery, aggravated assault, indecent solicitation with a child. And certainly those are typically associated with, or those types of crimes are typically associated with more significant harm to the community. So we obviously believe that level 8s for felonies, and then in the misdemeanor context, assigning that a Class A non-person misdemeanor if you cut your bracelet off is a better way of doing things. Also, and I think Ed is probably going to have a suggestion, as was on the House side. There was amendments in committee that added a couple provisions, and I think that's in his testimony as well, and he'll probably talk with you about that. But keep in mind that these folks that are on some type of supervision at the time, otherwise they wouldn't have their bracelets on. Because of that, they are potentially subject, if they commit, which would be this is a felony. If they commit that felony, they're subject to special sentencing rules, which they automatically are required to receive consecutive sentences, and then the court can actually order prison rather than probation. So just because they may fall into a presumptive probation range on this new felony, the court can still go ahead by special rule and do that. So there is a backstop there already, regardless of whether it's a level 6 or a level 8, that they could, under certain circumstances, under egregious circumstances, not only get consecutive sentences to what they were on supervision for, but also receive a prison sanction for it. So with that, we ask you to support this bill, and I would stand for any questions now or at the appropriate time. Thank you.
Scott, can you hear me?
Yes?
Okay,
I thought I may have astounded you or something.
we're having technical difficulties on our end. Let's. The audio is just not working in here. We will pick back up with questions for Scott. So Representative Carmichael, this gives you plenty of time to come up with some really good questions for Scott, okay? We'll be back in just a second.
I hadn't thought of any, but I've got some questions I want to ask you, Mr. Chair.
We ended up.
So Dennis, Steve is dropping something off to me in a few minutes. So I'm gonna open this up and turn on the audio.
No, you don't turn on your audio, we listen to his audio.
Oh, you have audio?
Yes.
Oh, great, okay.
Well, yeah, if you want to listen to you, if you can, do you have a link to the meeting?
Not right. I need to.
In the committee room, if you don't know, your audio is on at the moment.
Okay, I'll be back. Please watch this.
Well,
Somebody didn't realize the mics and.
except, really, he didn't realize that's where you saw it.
Well, I may go down and send it back in, but I.
There's still something.
The audio is on in the video. Right here, it's on. It's not now.
Is they still hear us?
Well, I don't know. They.
So we still have to have,
Somebody on here said. And that mic was hot, so. The others are.
I think Fred's might stop. Still.
Yeah, yeah. It's like this.
It's on.
Person's hot. No,
So,
what's a green light here?
means it's off.
What's a blue
That's
light?
off. That's off. Yeah, that's off.
Oh, it looks like there's a green light.
Yeah, and no, it's off.
The good news is we still have a week and a half to perfect the audio visual technology before we're done, so we might get there, guys. We're gonna have to give a little more time to get everybody back, so yeah, just hang on a little bit and We are still waiting on Representative Heiberger, so let's give him just a few more minutes and then we'll get started up. Okay, everyone, it looks like we're all here. Let's get started back up. We were ready for questions for Scott Schultz. Do we have any questions for Scott? I gave you all that time and no questions for Scott. Okay, thank you, Scott. So we also have written proponent testimony from the Kansas Association of Criminal Defense Lawyers. Is there anyone else as a proponent online? So we have now neutral testimony from Ed Klump, and Ed is joining us. There we go, Ed on WebEx. Good afternoon, Ed.
Thank you, Mr. Chairman. I hope I've got my audio on now. I am Ed Klump. I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and the Kansas Peace Officers Association. We're giving this neutral testimony. We've testified in opposition to these bills in the past, but given the study that was done on proportionality and the support of the Criminal Justice Reform Commission, we're submitting our testimony as neutral. We understand the sentencing proportionality. I actually served on the Criminal Code Recodification Commission. We had a subcommittee I was on that looked at proportionality along with a sentencing commission. So I've had some experience in looking at that and trying to figure that out. So we certainly understand the target here from the proportionality standpoint. Our concerns, though, we still remain concerned about people who remove or disable the tracking devices beyond just that it's a $28 device, especially those on pretrial release, probation, parole. The state has extended them the opportunity to remain free and in the public while wearing the devices, and they are breaking that trust. And our big question is, why are they taking the device off? Why are they disabling it and damaging it? And this concern is that they're doing that because they're going to go do something they don't want us to see where they're at or that they're at that location. We think that's especially troubling in cases related to domestic violence and stalking. Yesterday, I was in Senate Judiciary and they were having their hearing on House Bill 2071. You may remember that bill was the one about increasing the penalties for stalking juveniles. And it was very touching sitting there hearing the testimony from that mother and daughter who went through that. And it just reinforced in me why our associations are concerned about this. So, Mr. Chairman, on the second page of our testimony, I attached a copy of the amended version of House Bill 2027 because that didn't go through your committee, it went through corrections. And I wanted your committee to be able to see what those amendments were. I've kind of outlined them there in the on our testimony under the amendment consideration. I won't go through that, but those are all crimes related to commonly related to domestic violence. And so we believe those crimes, those misdemeanor crimes that we've listed there should remain as a felony, not as a misdemeanor when somebody removes that device. So we would ask that if you consider this bill to think about that underlying motivation of why a person would damage a device or remove it, and how that balances with the concerns for public safety and certainly concerns for the safety of victims and especially domestic violence victims. And so with that, Mr. Chairman, I will stand for questions.
Thank you, Ed. Do we have any questions for Ed? Not seeing any. Do we have any other neutral conferees? Oh, yeah, we do. Representative Heiberger.
Yeah, I have a question, Mr. Club. Ed, does your concerns about what people might do after they remove their monitoring device, are they any different from your concerns about what people might do after absconding in general?
Well, certainly there is a concern about absconders. I mean, there's no doubt about that. But a person that's wearing a tracking device is removing the item that allows us to look back and see if that person was at a location where a crime has occurred or where a victim has been re-victimized. And so I don't know, in my mind, it's a little more serious than the absconding, but they're both very serious because an absconder obviously has broken that trust as well, and we don't know where they are either.
Thank you.
Not seeing any other questions. Any other neutrals? Are there any opponents here today? Do not see any. I'll close the hearing on Senate Bill 4, open the hearing on Senate Bill 102, and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 102 requires an earlier notice of the anticipated release from custody of a person who might be a sexually violent predator to the Attorney General and the multidisciplinary team. And it also specifies where such person will be detained during their civil commitment proceedings. Section 1 amends KSA 5929 A02. That's the statute containing the definitions for the Sexually Violent Predator Act. We changed the definition of agency with jurisdiction to clarify that an agency releases a person confined or serving a sentence rather than a person serving a sentence or term of confinement. But the listed agencies stay the same. The Department of Corrections, the Department for Aging and Disability Services, and the Prisoner Review Board. Section 2 amends KSA 5929 A03. That statute currently provides that when a person may meet the criteria of a sexually violent predator, the agency with jurisdiction shall give written notice to the Attorney General and a multidisciplinary team 90 days prior to release or anticipated release of that person. This bill would provide that on and after July 1, 2022 and prior to July 1, 2023, such notice shall be given 90 days to 2 years prior to the release or anticipated release, and on and after July 1, 2023, then that notice has to be given 2 years prior to the anticipated release or the release of that person. Section 3 amends KSA 5929 A05. That's the statute that addresses the process for a court to determine whether probable cause exists to believe that person is a sexually violent predator. Current law in that statute provides that if a court makes that probable cause finding, then the
They are,
court
except
shall
this
direct
one has to go up to Harmony.
the person to be taken into custody and detained in the county jail until a time as determined, as a determination is made that that person is a sexually violent predator, subject to commitment under this act. the bill would retain that law, but create an exemption for a person who is subject to secure confinement at a correctional facility operated by the Secretary of Corrections, providing that when a person is no longer subject to that confinement, then the court shall direct the sheriff of the county where the petition is filed to transport the person to the county jail and detain that person in the county jail until a determination is made about whether they're going to be committed as a sexually violent predator. The bill also adds a new subsection F to 5929 A05 that applies when a person involved in a proceeding under the act remains subject to secure confinement in a correctional facility. This subsection would allow the court to secure that person's attendance at the proceeding by directing the sheriff where the proceeding will be held to take that person to the sheriff's physical custody and detain that person in county jail for such time that would be deemed reasonable to secure their attendance at that proceeding. And then a new subsection G is also added that provides that nothing in this statute creates a specific right for a person alleged to be a sexually violent predator. And I can take any questions.
Thank you, Natalie. Any questions? Do not see any. We will move on to proponents. First, we have Dorinda Mitchell.
Thank you, Chairman Dutton and members of the committee. My name is Dorinda Joe Mitchell, and I am the director of the Sexually Violent Predator Unit in the Kansas Attorney General's Office. Thank you for this opportunity to appear to offer testimony in support of Senate Bill 102. This bill modifies the notification process that identifies when an individual may meet the criteria of a sexually violent predator and be civilly committed for long-term care, custody, and control under the Kansas Department of Aging and Disability Services program, which is called the Sexual Predator Treatment Program, or as we often refer to it as SPTP. At the outset, I would point out that the purpose of this proposal of Senate Bill 102 is to reduce the amount of time that a person spends in jail while awaiting resolution of whether that person is a sexually violent predator. The county and the AG's office likes this idea because it reduces the costs to the counties in the amount of time that an individual spends in the jail. The respondent should like the idea because it generally reduces the amount of time that a person will spend in jail prior to an adjudication. And according to the Kansas Department of Corrections testimony, that individuals, about half of the individuals, have sentences longer than that 2-year notice provision that is being proposed in this legislation. That will apply and reduce the amount of time that a person spends in jail in at least half of those instances, if not more. In other words, instead of waiting for the sentence to be over, the actions will commence ideally while the person is still in the custody of the Kansas Department of Corrections serving their sentence for the crime that they had committed that called them to our attention in the first place. Our office has been working with the Kansas Sheriff's Association for many years on ways to reduce the burden that the commitment process places on our jails. The bill before you today is an attempt to address one of those concerns. We believe it is good public policy to transition more smoothly from the Kansas Department of Corrections to undergo the legal process of commitment during the time they are serving their sentence and be transported to the jail only if their sentence expires before the adjudication or the litigation becomes final. Under current law, the agency with jurisdiction, usually the Kansas Department of Corrections, notifies the Attorney General when an individual is in their custody who may meet the criteria of a sexually violent predator. That happens now under current law 90 days prior to their release. Then the multidisciplinary team in the Kansas Department of Corrections reviews the individual's mental health status and prepares an evaluation or more than one evaluation and gathers and compiles records for us. Then submits those to the Kansas Attorney General's office. In the Kansas Attorney General's office, there is a committee called the Prosecutor's Review Committee, which reviews the evaluations and the what we call the packet of information that's been compiled by the Kansas Department of Corrections. Those things are evaluated then by the second committee, the Prosecutor's Review Committee, and they make a recommendation about whether the case should be filed and that individual committed for long-term care, custody, and control. Those things have to happen before the petition is filed, and that process usually takes all of that 90 days. The commitment legal process then involves additional evaluation, judicial hearings, which can take many months. The individual is also entitled to demand a jury trial to determine whether the person is a sexually violent predator, which must be proven by the state beyond a reasonable doubt. Delay is often caused by the respondent in his search to obtain his own expert and discover the information and present his own case. So in other words, that process takes some time, and it would be better, and we are proposing that that be backed up and the case be started before the sentence expires. The current process envisions that all the litigation after a petition is filed be conducted while the person is held in the county jail rather than before his sentence expires. This places significant cost on our counties. The Kansas Sheriff's Association estimated that this cost is more than $600,000 per year. And if the individual has health concerns, then it can even be a greater cost. That is based upon an estimated 20 persons being held in the county jail at any given time. I checked today's records, and as of today, and these numbers change, are very fluid. As of today, there are 16 persons in jail awaiting commitment resolution. The Kansas Sexually Violent Predator Act also, not as a part of this legislation, as this proposed legislation, but it has a fund within the Attorney General's office to reimburse the counties for the cost of persons being held in county jails awaiting that sexual predator determination. However, the appropriations made to this fund fall far short of the costs that the counties must bear. For fiscal year 2022, the governor recommended appropriating only $50,000 to that fund. You can imagine that the cost to the jail, the cost of litigation, the cost of the experts, the cost of the legal counsel who are appointed to represent these individuals usually exceeds $50,000, and you add all of that up to the number of persons awaiting a determination, and that cost is substantially lower than the actual costs. County's expenses submitted to our office for reimbursement quickly deplete the funds and will deplete that $50,000 quite quickly. Once the fund is depleted, the only recourse for the counties is to seek reimbursement through the special claims process, the statutory process against the joint committee against the state. That brings us to the bill that is before you today. The bill would seek to reduce significantly the amount of time individuals spend in county jails awaiting a determination. Beginning July 1, 2022, the Kansas Department of Corrections notifies the Kansas Attorney General's office of the anticipated release of a potential SVP, someone that they're recommending that may meet the criteria. And that recommendation will come 2 years in advance of the potential release rather than the 90 days in current statute. This allows the commitment process to begin sooner. And while the individual is still in the Kansas Department of Corrections custody, ideally, this will allow some persons who are civilly committed to transition directly from the Kansas Department of Corrections to SPTP at Larned and not have to spend any time in jail. That is the goal and that is the ideal. Some individuals, as the Kansas Department of Corrections points out, have sentences shorter than 2 years and likely will spend some time in the county jail awaiting a determination on commitment proceedings. In addition, judges may require the individual to appear in person for hearings and almost certainly for trial. However, we believe this is a good step for greater efficiency and allows for the possibility of treatment closer to the time of the individual's release from the Kansas Department of Corrections. I want to point out that this bill does not change the person's rights to appear in court. Those are enumerated in statute. For example, at the outset, the probable cause proceeding, if the person wants to contest the probable cause finding that moves him to the jail, the probable cause hearing he is entitled as a matter of statute in 5929 A05 to appear in person at those proceedings. The state also wants that person there because one of our requirements is to verify that person's identity. And we can best verify the identity of that person and show that that individual is in fact the person named in the petition that we have filed by having that person there. That way, the doctor who is testifying that in his opinion, the person meets the criteria of a sexually violent predator can verify that person's identity and verify for the court that that's the person that he evaluated and is recommended for commitment proceedings. I would also note that and emphasize that these are civil proceedings. They are not criminal proceedings. And that means that the individual does not have the same due process rights that a criminal defendant would have when they're accused of a crime. This individual is not being accused of a crime by any way, shape, or form. These are not proceedings to punish the individual. These are proceedings to determine the person's mental health status. And if the expert testimony shows that the individual is likely to engage in repeat acts of sexual violence, most often these cases are sexual violence against children. If that person is likely to engage in repeat acts of sexual violence, then the individual is committed to a mental hospital, not a prison. These are civil commitment proceedings. with that, I would ask for your favorable consideration of this bill, and I stand for questions.
Thank you. Representative Carmichael with a question?
Thank you, Mr. Chairman. Ms. Mitchell, it's nice to see you. It's been literally years.
It has been. It's
It
nice
really
to see
has.
you too.
Indeed. Unfortunately, though, my job here requires me to ask you a few questions despite our long and
Happy to.
friendly friendship. First, the 16 people that are presently awaiting a determination as to whether they will or will not be civilly committed. When you were gathering that data, were you able to determine the range of time that they have been sitting in county jails awaiting that determination?
No, I did not. I
Do you
did not gather that. It'll be different in every case. I
Well,
know
that's why I asked for the
usually,
range. That's why I asked for the range.
If it can be anywhere from a few months to 2 years. 2 years is usually the maximum amount of time that these proceedings are litigated.
And these are people who have, quote unquote, paid their debt to society through the criminal courts. And they have not been civilly committed. Rather, they're just being held for 2 years without a judicial determination that they are a threat to others, or is there some interim procedure?
Well, there are procedures throughout the course of those proceedings. As I mentioned in my testimony, there are proceedings at the outset to determine if they want to contest the probable cause finding that takes them into custody, that puts them in the jail, then they may do so. And so there are proceedings at that time. Then there's another evaluation performed by the by a Larnard contract psychologist, and then that evaluation is evaluated, if you will, and the evaluation then, if we proceed with the litigation after that second evaluation, and 2 doctors and 2 committees of people have determined that the person is likely to engage in repeated acts of sexual violence, that individual then engages in discovery. The individual will retain his own expert, his or her expert, and there is often a significant amount of time that the individual has and undertakes to thoroughly find an expert to advocate for him or to evaluate his whether he meets the criteria under the state statutes.
And Ms. Mitchell, I will remember the arduous and acrimonious hearings that we had with representatives of KDADs under the prior administration concerning establishing some statutory rights for these folks who have done their time and not have been adjudicated as a danger to anyone. So I would like to, if I could, with the chair's permission, separate for purposes of my question the time between release from confinement, presumably Department of Corrections, and the determination of probable cause, and then look at the time between the determination of probable cause and a final adjudication. I assume you've had an opportunity to read Jennifer Roth's testimony for today. Have you seen it?
Yes, I have.
So then, as you know, at page 2 of her testimony, she says, also concerning is the provision that allows a person to be detained for any amount of time between the state filing the SVP petition and the court making a probable cause finding. And she says, parenthetically, current law is 72 hours or as soon as reasonably practicable or agreed upon by the parties. Close parent. Is she correct that this legislation will remove any statutory time limitation on how long a person could be held without even so much as a probable cause determination?
Well, no, because I think there's a confusion there between what this bill does. They're not being detained under the Sexually Violent Predator Act. They're being detained because they're serving their sentence. So there is no concern about them being in the jail. So that's why the being detained for any, detained under these proposals is not an issue. They're not being detained because of the Sexually Violent Predator Act or the commitment proceedings. They are serving their criminal sentence.
That presumes that the probable cause determination will be made before the completion of the criminal defendant's sentence. But as I understand what Ms. Roth is telling us, these folks can have a petition filed against them civilly, and they can rot in jail for years. And then once they're released from confinement, they then head to the county jail, and there's still no time limitation on when a determination of probable cause has to be made. Am I and Ms. Roth misinterpreting this?
Well, there is no determination. The Kansas Supreme Court has said that there is no time limit. The time limits are based upon each individual case and the individual circumstances in that case. This legislation and this proposal has nothing to do with the individual's rights or the amount of time they spend in jail. In fact, the whole purpose of this legislation is to reduce the amount of time that that person spends in jail.
You understand, though, that I look for loopholes and conflicts in the law, and I understand that people oftentimes have good intent, but as I'm sure you know, courts look to the black letter of the law rather than proponents, opponents, or legislators' good intent. And so the reason that I must inquire in more detail is I don't see that limitation. It looks to me like it's been left out of this equation, and that individuals could complete their sentence with Department of Corrections. A petition could have been filed days or weeks, months before, but no probable cause determination is made. These folks then head to the county jail, and there's still no statutory time limitation within which they have a right to be heard for the determination of probable cause, let alone proof beyond reasonable doubt. Am I missing something here?
No, what you have stated is accurate. The Kansas Supreme Court has said that there is no set time frame within which these cases must be tried. They are based upon the individual circumstances that are to which that particular case and that particular person is subject. As I'm sure you're aware, the Hendricks case, the United States Supreme Court unanimously overturned the Kansas Supreme Court's decision that there was a due process violation. The United States Supreme Court said, no, the statute does not provide a due process violation. There is no a due process violation in the law as it is written and as was submitted and argued to the United States Supreme Court.
And so, again, with the chair's permission, before we leave this area between completion of criminal sentence and determination of probable cause, it is the position of the Kansas Attorney General's office that the office is under no statutory obligation to bring these folks to a probable cause hearing within any particular time frame. And as the Kansas Attorney General interprets it, apparently there is no speedy trial or other obligation on the part of the state to bring these people to even so much as a probable cause determination, meaning that they could rot in jail for years. Is that really what the Attorney General?
No, that's
Leaves?
not what I'm saying. And first, I hope there's no rotting at all. But what I am saying is that there is a due process right to an expedient determination, but it is based upon the individual circumstances in the given case. And it is evaluated by the courts in that given case to determine whether the individual is prejudiced by the delay and whether that delay is reasonable. There's a whole set of standards that the Kansas Supreme Court has said that we have to evaluate. The legislature in 2015, in its wisdom, provided that these proceedings, because they are civil proceedings, that the parties coordinate with each other and that these cases be tried at a mutually agreeable time. That way, we are cooperating. We are working together with opposing counsel so that these matters are expedited and that these matters are adjudicated as quickly as possible. And as I alluded to earlier in my testimony, it is not the case that the government is dragging its feet or delaying these proceedings. We want the individuals to be adjudicated, and we want the individuals to be released if there is no case at that time to bring forward. So what we have found is that it is often the respondents' request to delay the proceedings in order to find experts, or often because they can't get along with the attorney to whom they have been assigned to represent them. There's often switches in counsel and requests to find another expert or a different expert to represent the individual. So they take the time that they need in order to present their best defense at the time of trial.
Mr. Chairman, I recognize our time is very limited, so I'm not going to be able to deal with that extensive answer here today. But I would, with your permission, like to turn to the second portion of this equation, and that concerns between probable cause determination and a final adjudication as to whether or not someone is in fact should be held for an indefinite period of time based upon beyond the reasonable doubt standard. Is there in this bill or anywhere else any statutory deadline by which these folks are entitled to have their jury trial, their day in court, and have that determination made beyond a reasonable doubt? Or can they continue to, if not rot, certainly sit in county jail for weeks, months, or years?
Is that question directed to me,
That
Representative
is a
Carmichael?
question for the conferee, Mr. Chairman.
Thank you. I greatly appreciate your concern, and that is a consideration of the purposes of the legislation itself. The reason that the individual is in jail is because they have been determined by two committees and by the evaluator, the doctor, to be likely to engage in repeat acts of sexual violence, and that they have serious difficulty controlling their dangerous behavior. So there is a lot of evaluation and review before that individual is even filed upon to seek his commitment in Larned. So it would undercut the entire purpose of the law to protect the public from that person's likelihood of engaging in future acts of sexual violence if you were to say they could be released.
That's not what I said, Ms. Mitchell, but to cut right to the chase of it is, the answer to my question is no, there is no statutory limitation, time limitation between a probable cause determination and the opportunity of that person who's being held in jail to appear before a jury and present their evidence and obtain an independent determination by a jury and a trier of fact. This bill doesn't provide for it, and it's not provided for anywhere else except to the extent that speedy trial applies, as explained in Ray Ellison. Correct?
Correct.
Thank you. Thank you, Mr. Chair.
Thank you, Ms. Mitchell. We will move on to Sheriff Easter, who might as well just join the committee as much as he's here and just joins every day. Thanks for being here.
Yeah, thank you. I appreciate everybody listening today. My name is Jeff Easter. I'm the sheriff here in Sedgwick County. I represent the Kansas Sheriff's Association on this current bill, as been discussed with Mr. Carmichael and Ms. Mitchell extensively here. So I'll keep mine a little bit shorter. The main thing here is that currently 90 days prior to the individual's release is when the process starts. As it's been pointed out, the process can take quite some time to get through. During that time, 90 days after this has occurred, they come into the custody of the sheriff of whatever county where the conviction took place. And so during that time frame, we're not providing any type of sexual violent predator type education, treatment, any of those type of things. The jails do not have the resources to do that. And so simply what this bill is asking for is exactly what I think, I understand Mr. Carmichael's arguments on due process and those type of things. But this bill is somewhat rectifying some of that, because I have had a prisoner in my custody for up to 2 years. Our average length of stay here for SVP folks is about 13 months. And so what we're asking is that this bill is proposing that process starts much sooner while the individual is in custody of KDOC. And while they're in custody of KDOC, still serving their sentence for their criminal criminal sentence of it, the process starts, which then is going to close the gap of the amount of time they're going to spend in a county jail, to the point that in some of those cases, they might not spend any time in the county jail, which then I think goes to the argument of Mr. Carmichael saying that they're sitting there and nothing's been done, nothing's been filed, those type of things. That's why we're a proponent of it. And we've worked long and hard with the Attorney General's office the last couple of years for this. The other thing that we have to understand is, first and foremost, reducing their time in the county jail will get them to the treatment programs with less or no delay upon the release from prison. County jails are not able to provide the very specialized sexual violent predator treatment programming with local mental health resources. This causes a delay in their treatment. The other thing is, there was a couple sheriffs that had some of these individuals for a long period of time. These individuals became very sick, and is hundreds of thousands of dollars in medical bills that small county had to pay for. There's no reimbursement for any of this stuff, and we just think that it's better for the individual themselves, because they're going through this process while they're under sentence, and they'll spend less time in a county jail receiving no treatment. And with that, I'll stand for any questions.
Thank you. Let's see, Representative Carmichael.
Thank you. And Sheriff Easter, I always appreciate you taking the time to be with us. I don't know how you and the chief manage to do what you do and still keep us safe. So thank you.
You're welcome.
Would it be a good idea to perhaps have something that is the equivalent to a statutory speedy trial statute for these folks that would set up some limitations and then give them the opportunity to request continuances chargeable to the defendant, much like what we do with criminal defendants in your custody, at least before the COVID crisis?
I'm not sure that I'm the one that's equipped to answer that, to be honest with you. As you know, civil is different than criminal. As Ms. Mitchell has testified to already, The Supreme Court has ruled that this procedure is fine. I simply rely upon what the law says. And any changes to that law or a Supreme Court decision is not based upon what I can do. I wait for those things to happen, and then that's the part that we follow. So I'm sorry, I don't think I can really answer that.
I wasn't sure that you could, but I always appreciate your expertise when you're able to provide it. Thank you, Mr. Chair.
Thank you.
Any other questions, committee? Do not see any. Is there anyone else here as a proponent? If not, we will move on to neutral conferees, and Randy Bowman is with us today. Good afternoon, Randy.
Good afternoon, Mr. Chairman, members of the committee. Hope you can hear me okay. So I won't spend a whole lot of time on this either, because that's been a very thoughtful and robust conversation. But we are neutral because we want to have your consideration, not to, is this the right policy? We've worked with folks for 2 years on this. We understand the interests and they make some sense on a lot of levels. But for us as a department, we want you to be aware of and hopefully consider with your appropriations colleagues the impact of doing this on the department. So as Ms. Mitchell fairly and accurately described earlier, there's about a 50% cut of this population. So if we move the time frame back from 90 days to 24 months, that also backs up the period of time ahead of that, which is about a 15 to 18 month period ahead of that, where we're working with these individuals, providing treatment and helping build the case that eventually may get turned over to the Attorney General's office for consideration for filing. So if you will, if half of our population is 24 months and under, you just move the time frame back, that works nice. And you just move the resources doing that work backwards in time. But where that leaves the gap is they're the other half of that population of sex offenders who come in with sentences that are shorter, 2 years and shorter. And how do you provide treatment to them to build a legally sufficient case, or really to hopefully treat them so we don't need to have these proceedings filed? But we still feel like we have an obligation to provide treatment to the other half cohort as well. Where today that other half cohort is just sitting on the back end, that when their sentence gets shorter, they'll get treatment. But to expand this out, we have to effectively, not quite, but close, double our treatment capacity to do this work. So we just hope that the committee, and again, I know you're not an appropriations committee, but many of you serve in those capacities on other committees, and you obviously vote on those matters. We wanted to bring that to your attention, ask for your consideration, that if this is the right policy, and I don't know from listening to the conversation today if that is or is not the case, that the treatment needs of these individuals be considered within the Department of Corrections when you get to that phase. So with that, I won't ask you for questions, but we'll take more of your important time today.
Thank you. Any questions, committee? Okay, anyone else here as a neutral conferee? We have written opponent testimony from the Kansas Association of Criminal Defense Lawyers. Anyone else as an opponent? We'll close the hearing on Senate Bill 102. Thank you both for being here, or all three of you for being here. And we'll now move on to House Bill 2366. Have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2366 creates guidelines for introducing testimony of jailhouse witnesses in criminal prosecutions. Section 1 requires a prosecuting attorney to disclose their intent to introduce jailhouse witness testimony. That prosecuting attorney would be required to provide the criminal history of the jailhouse witness, the witness's cooperation agreement, and any benefit that they might get. They also have to disclose the contents of the statements allegedly made and any information regarding the jailhouse witness recanting those statements, along with any information on other criminal cases in which testimony of that jailhouse witness was introduced or intended to be introduced. The court can extend the time for the prosecutor to comply if that witness was not known or the information could not be discovered in time. If the court finds that disclosing the information is likely to cause bodily harm to the witness, then the court can order the evidence be viewed only by defense counsel or issue a protective order. In a criminal prosecution for rape or murder, on a motion of the defendant, the court can conduct or the court would be required to conduct a pretrial hearing to determine whether the witness's testimony exhibits reliability and would therefore be admissible. Subsection B lists the factors that the court is required to consider, and if the prosecuting attorney fails to show by a preponderance of the evidence that that testimony is reliable, then the court would be required to exclude the testimony. Each prosecuting attorney's office would be required to maintain a record containing information on any case in which testimony of a jailhouse witness is introduced or intended to be introduced, and any benefit that would be associated with that testimony. And then the prosecuting attorney's office would be required to forward that information to the KBI. The KBI would be then required to maintain a statewide database that's only available to prosecutors with that information. If a jailhouse witness receives a benefit in connection with testimony, then the prosecuting attorney would be required to notify any victim connected to that criminal prosecution. If the testimony is admitted into evidence, then the jury shall be instructed that the testimony was provided by a jailhouse witness, and they would also be informed of any benefit associated with that testimony. And then subsection F provides definitions of what a benefit is and who qualifies as a jailhouse witness. And I can take any questions.
Thank you. Any questions for Natalie? Representative Carmichael.
Thank you. Ms. Scott, I'm at that point in my bill brief where it says the same or similar legislation was introduced last session as, and then there's a big blank. Could you help me fill that in? I think we've heard this before, haven't we?
Yes, Mr. Chairman, Representative Carmichael, last year, this bill was House Bill 2544. You guys did conduct a hearing on this bill and then it died in committee.
Thank you very much, Ms. Scott. My bill brief is complete.
Any further questions? Okay, we will move on to proponents. And first we have Tricia Bushnell.
Afternoon. Thank you so much for having me. And thank you for all the work this committee has done to prevent future wrongful convictions. I'm here again to ask you to keep that in mind. So as most of you know, I'm the executive director and legal director of the Midwest Innocence Project. We represent folks who were convicted of crimes they did not commit here in Kansas. And we have represented Floyd Bledsoe, Richard Jones, Lamont McIntyre, and most recently, Olin Pete Coons. We strongly support this bill and ask this committee to support this bill because it will help ensure that Kansans are only convicted based on reliable evidence and prevent wrongful convictions of other individuals based on unreliable evidence, right? So as Natalie explained all the different things that this bill does, I really want to bring home how this plays out in Kansas. We did hear this bill last year, and last year, there was some discussion about whether or not this is an issue even here in Kansas. And I think we can say now and know most clearly through the case of Pete Coons that there is work that needs to be done regarding jailhouse informants. So Olin Pete Coons was convicted and served over 12 years for a crime he did not commit. He was exonerated this last November, and a large basis of his wrongful conviction resided on jailhouse informant testimony. So Pete was not, they were not able to secure a full conviction at a first trial. And so at the second trial, the prosecutor, looking for additional evidence, was approached by a jailhouse witness who said, "Hey, I would like to come to you to make a deal." At that time, the prosecutor then reached out to Butler County prosecutor, which is where the jailhouse witness himself was housed, and asked about the informant. And those prosecutors wrote back, "The persons here who have handled his cases hate him. The impression I get is that he is not reliable at all." None of that information was ever disclosed to the defense. A vast majority of his convictions, which included over 28 convictions that involved fraudulent or false statements, was not disclosed to the defense. And there was a back and forth with the prosecutor and this jailhouse witness before trial. The prosecutor ultimately decided to present the testimony from this unreliable jailhouse witness. The facts that the jailhouse witness purported to offer did not match with any of the facts in the case. So this was a double murder. It later turned out to have been revealed as a murder-suicide. There was no indication that anyone had broken into the home. And the jailhouse witness said, "Well, That's because Pete came in through the window when there was nothing that showed that there was anything with the window. He said that Pete had arrived using a mail truck because Pete was a former post office worker. That mail truck did not work, did not run. There was nothing that was not even been possible for Pete to have done that. So there were already known factors of unreliability in his testimony, but he was allowed to testify anyway. And as a result of this, because he did not get a deal prior to trial, but the conversation was ongoing, he was able to testify that he didn't have a deal. And again, just as we've seen in other cases, the prosecutor was also able to bolster his credibility by saying, this is dangerous for jailhouse informants. Jailhouse informants coming forward, face risk of other inmates attacking them for being snitches. When in actuality, that isn't how things play out, because when people testify, they're often moved to segregation for a variety of different ways. But the reality was, this was the different piece of evidence between trial 1 and trial 2, and this is the evidence that convicted Pete Coons. It's very unfortunate you're going to hear from other people today, but unfortunately, Pete is not here today to testify, and he won't be able to, because last month, less than 4 months after he was exonerated, Pete died of cancer that went untreated and diagnosed in the 12 years that he was wrongfully convicted. But the provisions of this bill could have prevented that, could have prevented the lost time that he would have had with his family. Notably, the things that it provides tracking of when jailhouse informants and witnesses are used. So that means in a case like here, where the informant Rupert, when he was used as an informant, now other prosecutors can see that, and that information can then be disclosed. We will know exactly how many cases jailhouse informants are testifying in because it will be tracked. We actually don't know at this time. So last year, the Prosecutors Association said they thought it was very rare that jailhouse informants were used, but we don't have a way of knowing because we have no tracking. This would allow prosecutors to know the history of this. And that's important when you think about someone like in this case, Rupert, while he was waiting to testify against Pete Coons, yet again reached out from the jail to another prosecutor in another case and said, I would like to make a deal. Can I offer you information on this other murder? And then that individual went on to be convicted. So this is preventing the ability of folks like the Rupert to continue to work and be part of convictions when they have unreliable evidence. And how do they get information is, Rupert was in jail with Pete, and they moved him into the same cell for 48 hours. So at that time, he also had access to all of Pete's legal paperwork, and that is something that we've known and seen in other cases. So the tracking ability would allow us to know how often things are used and when there are repeat players. It also provides for enhanced disclosure. So what we're asking here, the prosecutors are already under an obligation to turn over this kind of evidence when a jailhouse informant is given a benefit, when they have other criminal histories. But what this is doing is two things. It, one, provides prosecutors a very quick way to get access to that information, right? There's now a clear database system and they can just hand over that information. And two, making clear to prosecutors what is this exculpatory information about a jailhouse witness. What we see time and time again, prosecutors and defense attorneys think differently about cases, understandably, in very different ways. And so when a prosecutor is looking at information in front of them, it may not be clear to them that that information can be used in an exculpatory way, and that would be required to be turned over under the Constitution. This bill lays out the specific information that needs to be turned over, so there's no question. We know it will go over, and later there wouldn't be an inadvertent moment where a prosecutor would not have turned something over just because they didn't understand. It would be clearly delineated and would prevent those issues on other appeals. It also requires a pretrial reliability hearing to make sure that the jailhouse informant is giving reliable testimony. As we can see from Rupert and Pete Coons' case, he would not have met a reliability hearing. He would not have been admitted. The facts that he gave were easily disputed, and it made no sense that Pete Coons would have come to him, having never met him and having spent less than 8 days around him, and provided any information. And the reality is, pretrial reliability hearings are not unique new things for jailhouse informants. We do this for forensic science, we do this for expert testimony, because we want to make sure that people are convicted on reliable evidence. We do not just allow any evidence in simply because it wants to be presented. And this is saying we know there is an inherent risk with the use of jailhouse informants with incentivized witnesses where the incentive is not clearly apparent, right? We see the incentivization for someone to lie in other cases. For example, when you see a family member or a friend who is presenting alibi evidence, the jury can understand and make the assumption in the critical view that that person may be incentivized, but with jailhouse informants, those incentives are not clear and unless they are offered. And in that same way, the jury would then be required to, a jury instruction would be given to the jury to understand that. And then further, there would be victim notification, because victims don't understand or know that perhaps the person who committed their crime is getting a deal for testifying against someone else. And this would allow them to have that information and to really promote more transparency and reliability in the criminal legal system. So, you know, we strongly support this bill. You will hear more about Pete, but I do just want to say, from the day Pete came home, he asked about this bill. The day he walked out, he asked about this bill. It would have made a difference. It will make a difference, and it will make sure that Kansans are only convicted on reliable evidence, and ask the committee to support it. I'm happy to take any questions now or at a future time.
Thank you. Committee, any questions? See any? We'll move on to Beth Powers.
Hi, good afternoon. Can you hear me?
Yes.
Great. My name is Beth Powers. I'm a state campaign director for the Innocence Project. Thank you for the opportunity to comment today. The Innocence Project is a national organization dedicated to exonerating wrongfully convicted people through post-conviction DNA testing and reforming the criminal justice system to prevent future injustices. We work locally with the Midwest Innocence Project in Kansas on policies to prevent and address wrongful convictions, and we strongly support this bill, HB 2366. And we thank the many of you on this committee who I know have worked hard to address innocence issues in recent years, including a number of reforms, and HB 2366 is another important step in preventing wrongful convictions. According to the National Registry of Exonerations, there have been 200 exonerations since 1989, where a jailhouse witness has been a contributing factor that led to that wrongful conviction. The most recent exoneration in Kansas was that of Pete Coons, which you've just heard about. Pete, who was in part wrongfully convicted due to jailhouse witness testimony. This legislation doesn't stop the use of jailhouse witnesses. It simply implements safeguards and transparency surrounding their testimony to help prevent wrongful convictions. The legislation is based on transparency measures that have been endorsed by the American Legislative Exchange Council and implemented in several other states. There are a few key elements of the bill which are included in my written testimony and what Tricia just went through also in my written testimony. I won't take your time up now, but I go through which states have adopted the different elements of this bill, all of which have been adopted in multiple other states. HB 2366 would improve transparency and efficiency in the justice system. When everything's done right at trial, there's more accurate outcomes, public safety is enhanced for everyone, the innocent are protected, and also there's fewer appeals and less money paid out through compensation of those wrongfully convicted. This bill really does benefit the entire justice system, and we hope you will support it. I'm happy to take any questions.
Thank you very much. Committee, any questions? Okay, let's move on to Ben Coons.
Thank you, Mr. Chairman. As Tricia and Beth have outlined for you, my name is Olin Ben Coons, and I'm here to speak on my father's behalf. Nearly 13 years ago, our family was torn apart by corruption, misconduct, and lies told by others. After my father was arrested, he was charged and convicted of a murder he did not commit. As was already stated, one of the key pieces of evidence that was brought against my father were the words of a man named Rupert, a jailhouse witness, a man that neither my father nor our family had ever known until he stood before us against my father in trial. A man who saw an opportunity and who told lies to a jury with no previous information believed him, and whose testimony ultimately led to my father's conviction and 13 years of imprisonment for something he did not do. If the jury had perhaps known that Rupert had made a deal and bargained for his benefit, for his testimony, or had been coerced into giving his testimony through questionable conduct by the DA, or if the jury had known that Rupert had done this many times before, or had my father's defense been given proper knowledge to review his testimony prior to the trial to formulate a proper case, or if he had even been reviewed prior, like any expert testimony is. Perhaps Rupert may never have actually testified. If any of these things had happened, my father would still be here and have a chance to be with us today. He would have been able to seek the necessary treatment for the cancer that ultimately took his life. And after all the lies and deceit that were brought forward into the light, 3 months seems an unfair reward. Though, after everything he had suffered, his deepest wishes were to see that this bill to be brought into law, so that others wouldn't have to suffer the way that we have suffered, and to give everybody a chance to defend themselves so that truth and justice can be upheld within the court of law. My father believed that the system would always find a way to bring it to light. And perhaps if this bill had been in place 13 years ago, he would have been a free man and would still be with us today. The course of history can be altered by the words of a single individual. In our case, Rupert's words left us with a history of pain and suffering that can no longer be mended. If there is any possible positive outcome that can come from this, it was my father's deepest wishes that this bill to move forward so that others would have a chance to hear only the truth spoken in the court, and for people to not be seen as opportunities. Thank you.
Thank you. Committee, any questions? Okay, let's move on to Melody Bitzer.
Thank you. My name is Melody Bitzer. My father was Kansas exoneree Pete Coons, but otherwise known as offender number 93985, since that is what the state of Kansas reduced his identity to, a series of numbers. I, however, have my own series of numbers that I would like to share with you. 12. That's the number of years my dad was wrongfully imprisoned. 14. That's the age that I was the day my family was torn apart. 27. The age I was when the truth was finally released to the public. 108. The number of days my father was allowed to be the free, innocent man that he was before the cancer that went undiagnosed and untreated during his wrongful incarceration took his life permanently. And that brings me to number 2366. Had House Bill 2366 been in place almost 13 years ago, maybe my father would still be alive today. At 14, I didn't really understand everything that happened during my dad's trial. However, now that I'm an adult, I'm able to grasp that situation much more accurately. And I have to admit, it makes me quite angry. Angry that lies are valued higher than the truth. Angry that an untrustworthy so-called witness and a selfish DA who used immoral practices and lies in order to win at the expense of an innocent man's life. I'm angry that there's still nothing in place to protect innocent people from this happening over and over and over again. I'm angry that there's no accountability for so-called informants or the prosecutors that use them, even knowing that they have records of lying. So opposing this bill could quite literally mean life or death for an innocent person. And I hope that if anything, our pain and suffering and my father's death won't be in vain. And I hope that our story can lead to change. Change that is very much needed in the state of Kansas to prevent this sort of tragedy from striking any other family again. Thank you for your time.
Thank you. Committee, questions? Okay, let's move on to Quinn Coons.
Thank you. So my name is Quinn Coons. I'm the youngest child of the late Olin Coons, and I'm here to speak on the importance of Bill HB 2366. I learned that the actions of an individual do not always affect just the individual. Due to the actions and words of an individual, words that were not checked, actions that were not investigated, my father spent 12 years wrongfully imprisoned, and my family spent 12 years in pain. I, who was only 7 at the time of his arrest, and 20 at the time of his death, have permanently lost the opportunity to ever get to know my father. In the short 108 days that I spent with him after his release, I got to know one thing about him, though. His desire for change, to keep anything as tragic and painful as what happened to our family to happening to anyone else's. By putting his system into place to make sure an individual's words and actions are true and honest, I believe we can keep his dream alive and make a positive and impactful change. There are many things I wish to do in his honor, and the most important, I believe, is carrying on his legacy and making a change in our society. And that's why I believe that the Bill HB 2366 is important. Thank you.
Thank you. Committee questions, Representative Carmichael?
Thank you. I appreciate your testimony and that of your family today. It's very powerful, and I know it's not easy for you to do. Could I ask you, what county was your father convicted in?
Wyandotte County, I do believe.
Thank you. Thank you, Mr. Chair.
Any further questions, committee? Not seeing any. We have written proponent testimony from Ross Minks from the Kansas Coalition Against Sexual and Domestic Violence, the Metro Organization for Racial and Economic Equity, Kansas Association of Criminal Defense Lawyers, Project for Innocence and Post-Conviction Remedies, and Americans for Prosperity. Anyone else here as a proponent today? Don't see anyone as a neutral conferee. Anyone as an opponent? Do not see any. We'll close the hearing on House Bill 2366. To Ben, Melody, and Quinn, thank you, all three of you, for coming to share your story with us today. I appreciate you doing that. I'm sure your father would too. Committee, that's all we have for today. Have a great evening, and we will see you all in the morning. Thank you. Our meeting's adjourned.